Sobriety checkpoints in Indiana. The Indiana Constitution, much like the federal Constitution, guarantees the right of people to be secure against unreasonable search and seizure. Unfortunately, I feel like there's a giant asterisk next to that constitutional clause that says, except for sobriety checkpoints. And whether or not I like it or whether or not my feelings on DUI checkpoints, in the state of Indiana, they are legal so long as they are implemented in a very specific manner and means. The courts have set up a 6-part test to determine whether or not a DUI/sobriety checkpoint is constitutional. Whether the checkpoint was carried out according to a neutral plan approved by appropriate officials, looking at the objective, timing, and other factors of the DUI checkpoint. It also assesses the discretion allowed by the individual officers who are at the checkpoint. It also looks at the degree of intrusion upon the individuals who are being shepherded through the checkpoint. And another factor is the safety and the conditions surrounding the checkpoint. And the last factor is the effectiveness of the DUI checkpoint. We're going to talk a little bit about those 6 factors and some of the more common problems that police agencies and organizations have in implementing a constitutional checkpoint. When looking at the neutral plan approved by appropriate officials, there's generally 4 factors that the court will look at. The first being whether the plan was approved in advance by ranking officers. The second factor of the neutral plan approved by appropriate officials is whether the checkpoint's location, date, and time were carefully chosen, especially in light of any potential safety concerns or inconvenience to the public. The fourth factor is whether there was any kind of advanced publicity for the checkpoint. And then another part of whether the plan was neutral and approved by appropriate officials is whether or not the checkpoint's guidelines were structured in a way that people understood, the people that going through the checkpoint understood that this is a routine type matter. It's kind of a fiction because DUI sobriety checkpoints aren't routine in any type manner, but that's one of the things that they look for when determining if a checkpoint is constitutional. The second big factor is the objective location and timing of the checkpoint. The objective timing and location of the checkpoint is rather giant umbrella term, and within that factor they're looking at a bunch of other issues. But generally, a constitutional checkpoint will show that this checkpoint was designed as a minimally intrusive, neutral effort to remove impaired drivers from the roadway before they hurt someone. And generally, unconstitutional checkpoints are going to show that the checkpoint is a good way to kind of slow down traffic and make sure everybody is doing what they're supposed to be doing. So there's a big difference between courts ruling this factor being constitutional or unconstitutional. To be constitutionally reasonable, the location and timing of a sobriety checkpoint should take into account police officer safety, public convenience, and effectively targeting the public danger of impaired driving. The third major factor is police discretion. A big part of showing whether or not a checkpoint is constitutional is there has to be a very minimal amount of police discretion. The obvious part about that is, hey, 2 cars come into the chute, and then when that second car leaves, 2 more cars come in, no matter who that is. Even though there may be some absurd results, well, the second vehicle was a bicycle. Well, the second vehicle was a fire engine. Showing that the officers adhere to that standard, no matter what next 2 vehicles there, we're going to put them into the checkpoint. That shows minimal officer discretion. Some other factors in determining whether the officers had minimal discretion is, were they told exactly what to say? Were they told to request license and registration? Were the officers told which standardized field sobriety tests to administer if the screening officers detected alcohol? And as everybody else here knows, that just simply because you have a set standard on how to do things does not necessarily mean that everybody actually does that. In fact, if just having rules meant that everyone complied, there wouldn't even be crime because, hey, you're not supposed to do X, Y, and Z. People still get in trouble for doing that. So simply showing that there's a plan is only half the battle. The state still has to show the officers acted in accordance with that neutral plan. Another one of the big factors is the degree of intrusion upon the motoring public. Again, Indiana Constitution says we're supposed to be free from unreasonable search and seizure. So what is the degree of intrusion? Is a checkpoint taking way too long? Are they stopping too many folks in an area that doesn't really have an issue with drunk driving? There's a bunch of little factors that pop into the degree of intrusion, but some of the big ones are checkpoint ahead signs placed in a way and manner that the public could see them, and then choosing whether or not they wanted to. Could the public actually avoid the checkpoint? Avoiding a checkpoint is 100% legal. Don't ever forget that. It's also legal for the police to follow someone that tries to avoid a checkpoint and stop them for a subsequent traffic violation. So if you do try to avoid a checkpoint, make sure you drive the speed limit. Additionally, degree of intrusion may not seem as obvious as some of the other ones, but was there advanced publicity for the DUI checkpoint? That will actually affect whether or not the degree of intrusion was constitutional or unconstitutional. Again, just because the degree of intrusion was planned ahead does not necessarily mean the officers implemented it in that way. They have to show that there was a plan and they adhered to it so that the degree of intrusion upon the motoring public is very minimal. One of the things that many attorneys overlook, and it's one of the 6 major issues as to whether or not a checkpoint is constitutional, is whether or not the checkpoint was safe. And so what does that mean? Well, maybe there's an issue with drunk driving at location A, but it's dark, there's no shoulder. To stop people there would put officers and civilians at risk. So the courts actually look at whether or not conditions are safe where the individuals are pulled over for the checkpoint. Again, many people overlook this, but we have seen at this law firm significant deviations from the approved protocol for checkpoints. And when confronted about why there were deviations, the checkpoint commander would say, well, I couldn't put the sign at X where someone could safely turn because, Mark, putting the sign there wouldn't be safe. Well, sir, if it's not safe to put the sign there, the conditions of that checkpoint likely are not safe. That's something that's overlooked often because, hey, there's police officers here, it's probably safe, but it's deeper than that. And that's something that the Court of Appeals and the Indiana Supreme Court will consider in determining whether or not a checkpoint is safe. The last issue for constitutionality of a checkpoint is whether or not the checkpoint is effective. I'm going to tell you, ladies and gentlemen, right now, I've done lots and lots of DUI checkpoint cases. Most officers who work the checkpoint case say, Mark, they're good at deterring drunk drivers, but they're not effective. You take those same 10 officers who are working a checkpoint and you have them driving around the area, each officer will likely get 2, maybe 3 DUIs in a given weekend night. Whereas if you do a checkpoint and 500 cars go through that checkpoint, you may get an apprehension rate of 1.5% to 2%. That is far less than the 20 or so DUIs 10 officers will likely get just actually canvassing the area. And a counter argument to that is, well, Mark, it's federal dollars, so we have to spend it or we don't get it. I don't think that's a good way to justify anything. Well, if money's there, might as well spend it. I think DUI checkpoints in Indianapolis, and Indiana specifically, abysmal effectiveness rate. In closing, if you're facing a checkpoint case, make sure your attorney has experience doing checkpoint cases. Make sure he gets the checkpoint manual from whatever relevant agency did the DUI checkpoint. And then make sure that the attorney, your attorney, actually makes sure the law and the checkpoint manual is followed. Because simply having a plan does not guarantee that the plan was executed. DUI checkpoints are legal in Indiana, but they're only legal if they're done 100% right. If you have any questions, give me a call, 317-632-3642. And remember, always plead the fifth.